Hi, my name is Gabrielle Lese and I'm a trust and estates attorney at Anderson Kill. I help my clients with their estate plans. I love working with my clients on their individual plans because it's very personal. No two matters are exactly the same. The estate planning process is driven largely by legal considerations, but very often questions come up that are not necessarily legal. That's what I'd like to talk about now. First, should I share copies of my estate planning documents with my family? Let's address the will first. In a will, you leave instructions to your heirs about distribution of your assets, and you name an executor to follow those instructions. Surprisingly, there's no obligation to tell the nominated executor about this appointment. So it's really a personal question. But if you play it out, imagine something happens to you and one of your children is named as executor. Would you want that child to be surprised by the nomination or prepared? It's easier to digest this information while people are not grieving. So letting the executor know during your planning is wise. As for sharing a copy of the will itself with the executor, there are two reasons you may want to do that. Number one, the will has the law firm name on it, so the nominated executor will know who to contact. And as for details in the will doesn't have asset information in it. It just contains your directions. So it might be, for example, in equal shares to my children. So sharing the document gives limited but very helpful information to the executor. Speaking of details, many clients choose to share a list including asset details with their executor so the executor knows what the client has. This can be a simple Excel spreadsheet with line items of bank accounts, life insurance policies, etc., and can include as much or as little as you like. Account numbers, values, passwords. The list makes it easier for the executor to do his or her job and marshal the assets. Overall, aside from sharing the will with the executor, you may choose to discuss your plan with your family and heirs. As I mentioned, it's helpful for your heirs to get this information during your life to understand their role and your intentions. These are not always easy conversations, especially where the plan is more complex and each family is different. But addressing these topics during the planning process puts everyone on notice of your intentions. And just a note that frequently a plan will also include a trust agreement, naming a trustee to follow directions. The same considerations apply in terms of a trust. Now let's turn to other documents in a plan. First, the healthcare proxy. I often am asked what to do with my healthcare proxy. This is so important. The healthcare proxy names an agent to make healthcare decisions for you if you can't make them yourself. It is usually needed at a critical moment when time is of the essence. So it is best to keep tabs on this document. I tell clients to forward a copy to their primary care physician and to the named agent to keep it easily findable. Some people even keep it on their phone in files in case of an emergency. Now, the power of attorney. The power of attorney names an agent to step in for you for non-healthcare transactions such as banking, for example. When needed, it's very important. If you trust your agent, you should send a copy to him or her, and in some cases, it's also wise to contact your bank to let them know of the power of attorney, as banks sometimes have their own forms they ask you to fill out in addition. Thank you for listening, and if you'd like to speak about your own planning, please feel free to contact me.